Noel Conway suffers from motor neurone disease and has been told he has less than 6 months to live. The High Court has ruled that the court should not interfere in an issue that's been debated more than once in Parliament. We're joined from central London by Dr. Peter Saunders, who's the campaign director for the Anti-Euthanasia Alliance Care Not Killing. Peter Saunders, a very good afternoon to you. We've seen these challenges go to the High Court before. This time this is not where the matter rests, is it? There's going to be an appeal to the Supreme Court.
Yes, we have seen these cases and we have every sympathy with Mr. Conway in his predicament, but we're not surprised by the decision today, and we are quite pleased with it because there would have been a lot of collateral damage had it gone through. There have been many court cases before. We had Diane Pretty, Nicklinson, Lamb, Martin, now Conway. There's another one, Omid, coming in the next few months or so, but all of them have fallen flat and have failed to get the decision that they wanted. And that's not surprising when you look at how British parliaments have dealt with the issue as well. We've had in the last 15 years 10 attempts to change the law through various British parliaments, and every single one of them have failed. And they've failed because MPs right across the House have been concerned about issues of public safety. And the crux of this case really was that Conway was arguing that that the blanket ban we have on assisted suicide was breaching his right to private life. And the court was not saying he didn't have a right to private life, it was saying that it needs to be balanced above with other considerations, and in particular in the interests of public safety, for the protection of morals, protection of health, and perhaps most notably of all for the protection of the rights and freedoms of others. So this was an issue about the balancing of rights, and the court felt that his rights under the Human Rights Act were not in conflict with the Suicide Act, which has this blanket ban, and so his appeal was actually dismissed.
Peter Saunders, just to be clear, when you talk about public safety and collateral damage, I mean, that may leave some people slightly puzzled, but your great fear in all this is that quite a narrow legal judgment applicable to one individual, one particular type of dilemma, may then through case law and subsequent judgments be rolled out such that it's extended, for instance, to elderly people who may begin to feel the pressure that they should end their own lives or seek help in ending their own lives, even though there's no pressing clinical need so to do.
Absolutely. The key thing is that this case is not just about Mr. Conway, because he was trying to establish a legal precedent whereby anybody in his position, so any mentally competent adult with 6 months or less to live, would be able to make use of this facility that he wanted. And the whole problem with that is that if you change the law to allow assisted suicide or euthanasia in any circumstances at all, and we've seen this in other jurisdictions, you inevitably end up placing pressure on vulnerable people to end their lives, people who are disabled or who are in despair or depressed or elderly may feel pressure, whether that's real pressure or imagined, because they're lonely or isolated, to end their lives, so as not to be a burden upon relatives or carers or on a society that's short of resources. And it's this that Parliament was worried about. So one can, on the one hand, have every sympathy with Mr. Conway, although he's a very rare case. There are 5,000 people with motor neurone disease in Britain. The vast majority of them do not want so-called assisted dying. They want assisted living. But there are people like him. But the issue is the effect on the society generally and on other vulnerable people. And it was interesting, the judges took very, very seriously the evidence that came from two particular groups, the medical profession first of all, who said that allowing this would undermine the trust between doctors and patients. And they put forward evidence from the BMA, the Royal College of GPs, College of Physicians, but particularly the British Geriatric Society, who they quoted at length. And then the other group that was very concerned were disabled people. Two groups, Scope and Not Dead Yet UK, had very powerful evidence. So this is why politicians from whatever part of the political spectrum see this as an issue of public safety, not just involving a few individuals, but having widespread repercussions potentially.
Peter Saunders from Care Not Killing, thanks very much.